Hi, Michael Kushner here, and it's time for another 1-minute attorney tip, where I provide California homeowners with powerful legal tools to hold their HOAs accountable. Today, I want to discuss emotional support animals, which are not the same as service animals, which I'll cover in my next 1-minute attorney tip. Emotional support animals are covered and protected under federal and state law, such that HOAs must provide reasonable accommodations to people who need such animals. Now, there are things your HOA can and can't do with respect to an emotional support animal. They can ask you for a note or some documentation from a medical professional that states that you have a condition that requires your use of an emotional support animal and that the symptoms that you have would be alleviated by such use. That could be any medical professional. It doesn't have to be a psychologist or psychiatrist. It could be your primary care doctor. The code just says medical professional. What they can't do is demand that the letter include details regarding a diagnosis. They can't ask you to be registered in some database of registration for these types of animals, and they can't charge you a deposit or a fee or a processing fee. They can't do any of that. So a simple one-sentence letter from a doctor indicating that you suffer from a condition whose symptoms would be alleviated by an emotional support animal would be sufficient under the law. Now, if your HOA is standing in your way of obtaining an emotional support animal that you need, or they're dragging their feet and granting the reasonable accommodation, then give us a call at MBK Chapman, and we'll step in and make sure the board follows the law. I'm Michael Kushner, and this has been another 1-minute attorney tip. If you like this episode, please hit the like button and subscribe to the podcast, HOA Hell. If you'd like to leave a comment or suggest another 1-minute attorney tip topic, please leave a comment in the comment section. Until then, have a great day.